Supreme Court has essentially reshaped American life.
It's going to be legal chaos.
Where abortion is legal in about half the states, illegal in half the states.
Even though America was braced for the decision, it was nonetheless momentous. 50 years' worth of women's rights in America overturned in an instant as the Supreme Court, whose very purpose is to protect civil liberties, took away the constitutional right to abortion.
So what does this mean for you today?
This means everything. This is the moment that we have been working towards. This is a historic day. This is the first day that America is living in a post-Roe generation.
Roe v. Wade is going to go!
We are dancing on the grave of Roe versus Wade. It's like taking Normandy Beach, and we will get to Berlin. We will make it a crime in all 50 states to kill a baby.
In a divided America, there was unbridled joy and resolute anger.
And I am absolutely terrified. I'm so beyond livid at what is going on, and I'm going to turn my fear into anger. There will be no functioning society without women, and the women are pissed.
This decision! Illegitimate!
More than a dozen Republican states have trigger laws which immediately kick in now and ban abortion. Missouri moved first, then Kentucky, Louisiana. But the rest will follow, forcing women, those who can afford it, to travel to Democratic states like New York or California, where the procedure will still be legal. For now.
In its history, the Supreme Court has made profound decisions, abolishing segregation in schools, same-sex marriage, all of them expanding American freedoms. This is the first time it's issued a major ruling going in the opposite direction, taking those liberties away, and they've signalled they may not stop at abortion. For while Justice Alito, who wrote today's decision, assured it wouldn't impact other freedoms, Justice Thomas simultaneously called for the court to reconsider its rulings on contraceptives and same-sex marriage.
And it's insane that we're going all the way back to the way things were in 1970 and that women's rights are being stripped away. And I do think that they will not stop here. For some reason, our Supreme Court has chosen to not protect American citizens' rights to choice.
But the reason is all too clear. Donald Trump's deliberate move to install pro-life conservative justices meant the writing for abortion was always on the wall, as his successor emphasized today.
It was 3 justices named by one president, Donald Trump, who were the core of today's decision to upend the scales of justice and eliminate a fundamental right for women in this country.
Good evening. In a landmark ruling, the Supreme Court today legalized abortion.
A constitutional right that's been in place for half a century, but whose removal will now upend American life. And remember this, in taking away a woman's right to choose, the Supreme Court has gone against the will of the people, the majority of whom polls consistently show back abortion rights. That conservative justices did it anyway says everything you need to know about American politics in 2022 and its festering divide.
The Supreme Court's ruling on abortion. Protests were held in multiple cities. More are scheduled for this weekend. The ruling reverses a nearly 50-year-old precedent, ending the federal protection of a woman's right to an abortion. Jan Crawford has more on the court's historic decision.
When the crowd heard the court had overturned Roe v. Wade, there were cheers. It took every single one of us, people across the political and ideological spectrums, to make this a reality.
A reality that for abortion rights supporters was hard to believe.
This is a nightmare. I'm 21 and I'm terrified.
In the 5-4 vote, the justices overturned the landmark 1973 ruling that guaranteed a woman's right to abortion, sending the issue back to the states to set their own policies. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences, wrote Justice Samuel Alito in a decision joined by 4 other conservatives. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. 26 states had asked the court to overturn Roe. 13 already have laws on the books that would ban abortion almost immediately. The others are poised to ban or greatly restrict it.
Today, the Supreme Court of the United States expressly took away a constitutional right from the American people.
President Biden blasted the decision.
It's a sad day for the court and for the country.
On Capitol Hill, Democratic lawmakers marched to the court while Republicans said the ruling was overdue.
Alleluia. I woke up this morning praying for this, and I never thought that it would happen.
Good evening. In a landmark ruling, the Supreme Court today legalized abortions.
It took almost 50 years of annual marches for life, political muscle, and justices with a strong conservative legal ideology. Chief Justice John Roberts voted to uphold the 15-week Mississippi abortion ban, but refused to join the majority decision to overturn Roe or a subsequent 1992 opinion. With the court's newest justices, all nominated by former President Trump, there were 5 votes without him. Republican Susan Collins and Democrat Joe Manchin, who voted for Neil Gorsuch and Brett Kavanaugh, said they were duped, with Collins releasing a statement that they were both insistent on the importance of supporting long-standing precedents. But also a factor, the 2020 death of Justice Ruth Bader Ginsburg, a champion of reproductive rights, gave Trump his 3rd nominee, who provided the key 5th vote. The 3 remaining liberals joined in a fiery dissent. Whatever the exact scope of the coming laws, one result of today's decision is certain: the curtailment of women's rights and of their status as free and equal citizens.
The Comstock Law of around 1873 prohibited the research, publishing, and public discussion of contraception or sex education. United States v. Dennett of 1930 challenged the Comstock Law by legalizing the distribution of sex education material through mail. Then there's this video documenting the history of contraception, which also includes the relevant rulings. Oral contraception was discovered in the late 50s, early 60s, but it wasn't available to women until 1965. Griswold v. Connecticut of 1965 reserved married couples privacy to buy and use contraception. The decision to use contraception was left to the discretion of married couples, and the government chose not to interfere. This was arguably the first use of privacy with regards to a person's body and reproduction, by citing the related components of the 4th, 5th, and 9th Amendments, as well as the Bill of Rights. While oral contraception became available in 1965, its use was restricted to married women only. Eisenstadt v. Baird of 1972 ensured that all women had access to contraception based on the equal protection component of the Constitution. The argument was restricting contraception to married women discriminated against single ones based on their marital status, which went against the equal protection principles of the Constitution. Justice William J. Brennan, who wrote for the 6-1 majority, argued, quote, "If the right to privacy means anything, it is the right of the individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child." Have this argument at the back of your mind. Then came Roe v. Wade in 1973 that legalized abortion in America for over 50 years, until just recently when that decision was returned to the states, with half of red America criminalizing abortion and the other half of blue America maintaining access. States were allowed to regulate but not outlaw abortion at the 2nd trimester, and they were allowed to ban it completely in the 3rd trimester on the grounds of viability, except when the mother's health was at risk. Planned Parenthood of Central Missouri v. Danforth of 1976 allowed abortion without the consent of the father, because her body, her choice, with the argument being, The state cannot award veto power to the spouse, the man in this case, which itself is prohibited from exercising. The court argued that a woman's right to choose outweighed the father's right to associate with his offspring. It would be interesting for our viewer to note that the child support system was set up in 1975 to ensure that men did not have any rights to opt out of parenting. While the patriarchy was limiting the woman's right to herself, eliminating the need for the father's consent, it was also taking away the man's right to choose. All the bases of women's reproductive choice, especially privacy and equal protection, were tested through the gender lens and they failed. In Dubé v. Wells of 2006, the courts argued that under no circumstance could men opt out of parenting. Michigan Paternity Act, which mandates child support for out-of-wedlock children, was cited in the case together with Michigan's safe haven and abandonment laws that raise the ease of women giving up children they've had for adoption. In simple terms, Michigan law doesn't exercise equal protection since it bans men from exercising the choice of opting out of parenting, while women are allowed to give up parental responsibilities even after the child is born by making it as easy as dropping the child at a police station or church or hospital and that's it. The courts in Dubé v. Wells agreed that forcing men into parenting is discriminatory, but they argued that discrimination was necessary as it served important government objectives of protecting the child. Remember, safe haven laws make it easy for women to give up children for adoption up to 1 year after birth. In Eisenstadt v. Baird of 1972, the court argued, quote, "If the right to privacy means anything, it is the right of the individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child." In Dubé v. Wells of 2006, the courts argued, quote, "A regulation infringing upon a fundamental right will only be upheld if it is narrowly tailored to serve a compelling state interest." We find that the right to privacy, articulated in the Supreme Court's substantive due process jurisprudence, does not encompass a right to decide not to become a parent after conception and birth. The underlying purpose of the Paternity Act is to ensure that the minor children born outside a marriage are provided with support and education. This is undoubtedly a legitimate, and an important, governmental interest. End quote. When it comes to safe haven laws, the patriarchal government doesn't seek to ensure that children born outside marriage are supported. The point in all this being, when it comes to parenting, men don't have choice while women have choices, plural. After conception, a woman, without having to consult with a man, could decide to terminate or keep the pregnancy. If she doesn't keep the pregnancy, she opts out of parenting and that's done. Society and feminists call that choice or healthcare. If the man wanted her to keep the baby, well, it's her body, it's her choice, she gets to decide what she wants to do. When she decides to keep the pregnancy and have the baby, the argument changes from it's her body, her choice to she didn't make the baby alone so she shouldn't have to raise it alone. Feminists and like-minded people call the recent overturning of Roe v. Wade as an attack of women and the government infringing upon women's rights to decide what they do with their bodies, even though the government was executing a legitimate, and an important, governmental interest as argued in Dubé v. Wells of 2006. Feminists believe in choice, but only female choice. Women scream on top of their lungs about choice, then turn around and make sure the government takes away a man's choice of what to do with his income in the name of child support. So much so that men are jailed for child support arrears. In the case of reproductive choice, what would equality, especially equal protection under the Constitution, look like? Isn't it both men and women having the choice of opting out of parenting? In feminists' head, when they were crying equality upon the overturning of Roe v. Wade, they believe equality is women having choice in exercising bodily autonomy while taking away men's choice of exercising financial autonomy. Of course, that's nothing close to equality but unearned female privilege.